Hello, my name is Mike Tessara and I prepared this video presentation entitled Judging Judges, and I'll be looking at the case of Stradford and Judge Vasta. And just by way of background, this is a case where Judge Vasta imprisoned a person for breaching orders in the family court, and there was a case taken against him by Mr. Stradford. That's not his real name, it's a pseudonym, and also the Commonwealth Government and the State of Queensland, and he was successful against all three before Justice Whitney of the Federal Court. So it's a pretty remarkable case, and I guess you can see there Judge Judy just shaking her head at the something, and I think by the time you've listened to this particular case, you'll be shaking your head as well. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I've been running my own practice about Tessara Legal Consulting for about 17 years, and I help companies and individuals with competition and consumer law matters. I also do some expert consultancy work for a number of legal publishers on competition and consumer law. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including enforcement and mergers. Now, the outline's pretty straightforward. Look at the facts, the issues that the judge had to consider, the findings made by Justice Whitney, also the fact that this case has been removed to the High Court for consideration, so it sort of bypassed the full federal court, and some legislative changes which have been introduced which address the issue at the Commonwealth level. Now, the background facts are fairly straightforward. There'd been some property settlement between Mr. Stradford, not his real name, and his wife, and he'd made an application to have that property settlement adjusted. So he made an application to the family court under the Family Law Act. And there are a number of earlier interlocutory proceedings, and the matter was listed before a judge for directions, and both parties were unrepresented. And the matter came along before a judge for final hearing, and that's where the problems arose. There were allegations made by Mrs. Stradford that Mrs. Stradford had not complied with the early orders, so there was an argument put to the court that Mr. Stradford had not fully complied with orders made earlier in relation to his property holdings and other financial interests. And Judge Vasta looked at the various issues and seemed to just accept that there was a problem here, and he made that comment in his judgment at that stage. And believe me, if there isn't the full disclosure, there will be consequences, because that's what I do. If people don't comply with my orders, there's only one place they go. Okay, and I don't have any hesitation in jailing people for not complying with my orders. So he's saying to, I guess, Mr. Stradford at that stage that if he doesn't disclose everything he's supposed to disclose, he's going to go to jail. Now, the matter went away, and there were affidavits signed by Mr. Stradford where he disclosed various financial records, and then Mrs. Stradford filed an affidavit where she did allege again that Mr. Stradford had failed to disclose relevant information. Then the matter came before a judge, Judge Turner this time, for directions, and there was allegations that a failure to comply with the orders obviously raised issues of potential contempt. But Judge Turner did not actually resolve that matter between the parties. Rather, she made an order to adjourn the matter to a later date for hearing of a contempt application. Now, on the 6th of December, the matter came before Judge Vasta, and I guess that was to determine whether there had been contempt. But the funny thing here was Judge Vasta seemed to have assumed that a finding had already been made that Mr. Stradford was in contempt, and as a result, he gave an extempore judgment on that day, finding that Mr. Stradford was in contempt of his orders that were made earlier, and then he ordered that Mr. Stradford be sentenced to imprisonment for a period of 12 months to be served immediately. So effectively, he was taken into custody on the day and taken away to the correctional facility. And the idea was that he would be released on the 6th of May 2019, and the balance would be suspended. So it's a period of suspended sentence. So on the same day, shortly after, the judge signed a warrant of commitment, and then once he'd signed that, the two guards for MSS took Mr. Stradford into custody. So MSS are the security providers to the federal court and the family court. And once he was in custody with MSS, the police were called, the Queensland Police were called, and they arrived at the court and handcuffed Mr. Stradford and took him to the Roma Street watch house, where he remained for about 4 days before being transferred to the Brisbane Correctional Centre. Now, the interesting thing here, he had a very traumatic experience over those few days. He spent another couple of days at the Brisbane Correctional Centre, and there was a number of stories that suggested that he was in fear of his life. Firstly, he didn't really look like a criminal, a businessman, and so there was suspicion by some of the inmates that he might be a police informant or an undercover policeman, so various threats were made against him. Other unfortunate things happened. When he got to the correctional centre, I believe there were no men's shorts left, so they gave him a pair of women's shorts to wear, and so you can just imagine walking around a jail wearing women's shorts. That would have resulted in some hostility towards him probably. And I guess the other thing, he was put in a cell with another inmate who appears to have had some mental health problems. And would you believe the person who he was put in jail with, his name was actually Mr. Strange. So there were a lot of incidents described in Wigney's judgment of the 6 days he spent in jail were very traumatic. On the 12th of December, the matter was listed again before Judge Vasta to hear an oral application to stay his earlier orders, and on that day Judge Vasta issued another extempore judgment in which he granted the stay application. I think Wigney in his judgment states that there seems to be a realisation by Judge Vasta that he did make a number of mistakes in his initial decision to imprison Mr. Stradford. Now, the issues from the case, firstly, Wigney had to identify the errors made by Judge Vasta, then the torts that may have been committed by Judge Vasta. There were 2, collateral abuse of process and false imprisonment. Then whether there's any judicial immunity, whether Judge Vasta, even if he had committed those 2 torts, was not liable. Whether the Commonwealth and Queensland Government were liable. I guess Commonwealth Government, MSS security guards took him into custody initially, and then the Queensland Government, the police took him from the court to the watch house and then to the jail. So they had potential liability for their conduct. The damages issue, the first was damages for deprivation of liberty and whether aggravated exemplary damages should be ordered, and then other damages. Now, this is just to give you a flavour of the interactions between Judge Vasta and Mr. Stradford. Here you've got Judge Vasta saying, "I've told you I will put you in jail in contempt of this court if you talk over the top of me. Do you understand? I'm not happy at all with you, but I'm happy for you to think about this because your disclosure at this point has been absolutely abysmal." So there's obviously a lot of hostility, quite emotive language. "And if it is that I order this and you do not disclose your superannuation, your current bank accounts, all the accounts that you have now been disclosed, that you say have now been disclosed, and when they were closed and what the balance was when they were closed, all of those matters need to be given to Mrs. Stradford by a certain time, and I would think it would be within 2 months. And if that isn't given to her, if it is that she comes here and she complains that she has asked for these things and you have not given them to her, bring your toothbrush, okay? So you have to think about it." So he's actually being very threatening towards Mrs. Stradford. You must comply. If Mrs. Stradford says you haven't complied, I'm going to put you in jail. So Justice Wigney concluded that Judge Vasta had made quite a number of mistakes in his decision. He firstly proceeded in apparent ignorance and disregard of the relevant provisions of the Federal Circuit Court Act and the Family Law Act, which dealt with how contempt was punished. So effectively didn't follow the correct procedures as set out in the legislation. Should be separately dealt with as a contempt of court committed in the face of or hearing of the court. Also, Wigney found that Judge Vasta had resolved or predetermined the issues before listening to Mr. Stradford. So he didn't conclude that Mr. Stradford had breached the disclosure orders. He didn't listen to Mr. Stradford at all. So effectively he prejudged the issues. He was determined to put Mr. Stradford in jail without really listening to what he had to say. The procedure was fundamentally flawed from the outset. Judge Vasta was found to have performed the roles of prosecutor, witness and judge, failed to follow the relevant procedures mandated under the rules. He also proceeded on this erroneous premise, which I mentioned earlier, that Judge Turner had actually already found Mr. Stradford in contempt of earlier orders, which he hadn't. He'd adjourned the matter, she had adjourned the matter for a consideration of that later on. So he assumed that Judge Turner had found contempt already. The conduct of the proceeding constituted a clear denial of procedural fairness, so not listening to the individual, predetermining the issues, etc. And the conclusion that Mr. Stradford had failed to comply with the orders made on 10th of August, Justice Turner's orders, was without any evidentiary foundation. There was absolutely no foundation to make that conclusion. That was the most puzzling aspect of the case, how Judge Vasta thought that a finding of contempt had already been made. So the first issue that the judge looked at was whether there'd been a collateral abuse of process, and he was mindful that the allegation that Judge Vasta instigated or maintained the consent proceedings for the improper purpose of forcing Mr. Stradford to capitulate in the family court proceeding and to effectively hand over everything to his former wife was an extremely serious allegation. And the thing the judge also said was that if Mr. Stradford did what the judge wanted, the judge would effectively forgive or overlook the contempt, and he would not put Mr. Stradford in jail. So the judge concluded that that was very serious conduct, that it was entirely inappropriate and bordering on improper. But he did conclude that, I guess, being such a serious allegation, that it wasn't established in this particular case. So he found that Judge Vasta had not engaged in a collateral abuse of process. The second issue was liability for false imprisonment. So it's clear that Mr. Stradford was imprisoned for 7 days as a direct result of Justice Vasta's orders, and there's quite a long discussion of the various factors, but given all the errors that I listed earlier, there was clearly no lawful justification for Mr. Stradford to be imprisoned. The imprisonment order and warrant were invalid, like there was no finding that he'd been in contempt, the procedure wasn't followed, the matters were prejudged. So effectively the imprisonment order and the warrant were invalid, no legal effect, so it follows quite automatically that the tort of false imprisonment was made out. The question then arises whether there's judicial immunity, and I guess he quotes the relevant law. It's well established that in superior courts, so the federal court, high court, state supreme courts and so on, a judge is not liable for anything that they do when acting judicially. And that's generally taken to mean when acting bona fide in the exercise of their office under the belief that they have jurisdiction, even if they're mistaken. So if they don't have jurisdiction, but they believe they do, they're not liable for false imprisonment, for example, or any other breaches. But there is no authority to the effect that judges of courts other than superior courts are not immune if they act outside the jurisdiction, whether or not they do so knowingly. So effectively, you've got your superior court judges, superior courts, and the judges in superior courts, and then you've got inferior courts, and the judicial immunity, as Justice Wigney read the cases, only applied to superior courts. So that meant that Justice Vasta, being in an inferior court, the Federal Circuit Court and Family Court, was not able to take advantage of the judicial immunity. So having regard to all the principles of judicial immunity of inferior courts that he went through, and he went through a lot of detail there, he concluded that the judge didn't have any immunity and accordingly was liable for any loss or damage suffered by Mr. Stradford arising from the false imprisonment. So he restated there, as an inferior court judge, the judge was not protected from liability arising from his imprisonment of Mr. Stradford. And it's clear that Mr. Stradford was not lawfully justified, his imprisonment was not lawfully justified because the order and the warrant were invalid and no effect. They were infected by manifest jurisdictional error. So the question arose as to whether the Commonwealth and the Queensland government were liable. And the key issue here is whether they were acting on the bona fide but mistaken belief that the imprisonment order and the warrant were valid. And he concluded that it didn't matter if the order is invalid and the warrant's invalid, you can't be immune from liability for that reason. And as you can see there, he was satisfied that the catalogue of errors made by the judge in ordering the imprisonment are considered individually, cumulatively, it can be safely concluded that the judge acted without jurisdiction. And, for the purposes of any available common law justification, defence relied on by the Commonwealth and Queensland. So they couldn't rely on any common law defence because there was simply no jurisdiction. So it followed in the circumstances that both the Commonwealth and the Queensland could not avail themselves of that common law defence, and accordingly they were also liable for the unlawful imprisonment and detention of Mr. Stradford. So the first question was to look at, in terms of damages, whether he should receive damages for deprivation of liberty, and the case law is fairly straightforward there, and the courts have concluded that when determining what the damages should be for deprivation of liberty, the court should take into account any conduct of the defendant up to the time of the verdict, which may have the effect of increasing the injury to the plaintiff's feelings, including whether the defendant apologised for the conduct. However, for a plaintiff to be entitled for aggravated damages, they must show something additional. They must show that the conduct was neither bona fide or justifiable. Now, it's clear that even though the judge and the Commonwealth and Queensland argued that they hadn't done anything wrong, they'd actually never apologised to Mr. Stradford for their conduct. Obviously, that doesn't make sense to apologise for something you don't believe is wrong. And they both conceded that the judge had actually erred in finding that Mr. Stradford was in contempt and ought to be imprisoned. They still maintained that the imprisonment was lawful and justified, so that the judge could imprison him and there was no breach of the law. So that provided the basis for an award of aggravated damages. All the boxes were ticked there. And he also considered that the thoroughly humiliating, demeaning and degrading manner in which Mr. Stradford was dealt with and housed both at the watch house and the jail significantly aggravated the injury to Mr. Stradford's feelings and mental state during the period of imprisonment. And it was said that there's nothing out of the ordinary. This is the way all prisoners are treated. And Justice Wigney's response was, it is no answer to say that Mr. Stradford suffered no more than the ordinary prison experience, whatever that may mean. I guess if he shouldn't be there, it couldn't be the ordinary prison experience. And it seemed to be a particular traumatic experience, firstly because he just didn't fit in, and people suspected that he was possibly a police informant or an undercover policeman wearing women's shorts. Clearly didn't help either. And he actually was on some medication which he wasn't provided with in jail, and it was a medication for a rash. So because he didn't get the medication, he broke out in a very bad rash during his time in imprisonment, which obviously made his period more traumatising. So effectively the judge looked at all the various issues and decided on damages, and he concluded that general and aggravated damages for false imprisonment and deprivation of liberty should be $200,000. And this was shared between Judge Vasta, the Commonwealth and the Queensland government. Exemplary damages were ordered against the judge, so that's pretty exceptional to do that, and that's obviously showing the court's disapproval of the conduct of the judge. And so there was a $50,000 order against Judge Vasta for exemplary damages, and then he obtained some damages for personal injury and loss of capacity, $59,000. Needless to say, Mr. Stradford did seek a lot more money, and his evidence in relation to his financial losses was very unimpressive. There was a lot of inconsistencies in it. He actually had obtained work following this particular incident, very highly paid work, which seemed to have not been fully disclosed to relevant experts. So his evidence is highly unsatisfactory. So I think that probably played a part in how much he recovered. He was seeking obviously a few $1 million compensation here. Now, subsequent to this, it's fair to say that the Commonwealth appealed both on behalf of the Commonwealth, and Judge Vasta and the state of Queensland appealed and went to the federal court. But then recently, in February, the causes were removed directly to the High Court. So the full federal court stage has been skipped, and the matter will be considered by the High Court sometime in 2024. So it's interesting that the High Court said, well, let's cut to the chase. There's no point going through the federal court. Whatever happens is going to be appealed. The issues are pretty significant, particularly the judicial immunity issue in relation to judges of inferior courts. However, it's really interesting that some legislation was passed quite quickly last year. It was obviously prepared quite soon after the case, and it was called the Federal Courts Legislation Amendment Judicial Immunity Bill, and it introduced a number of immunities in relation to various parties in the Federal Circuit Court and Family Court. Relevantly, it was aimed at ensuring that judges of Division 2 of the Federal Circuit and Family Court of Australia had the same immunity as Division 1 judges, so basically federal court judges. And this amendment would only apply prospectively, so anything beyond the date, which is in November 2023. So the issue of inferior court judges, at least at the federal level, has been addressed by the passage of legislation. And this is the relevant section that's been included in the Federal Circuit and Family Court Act, Section 277A. A judge of the Federal Circuit and Family Court of Australia, Division 2, has the same protection and immunity as a judge of the Federal Court and the Family Court of Australia. So really, it makes the High Court issue somewhat moot, at least going forward. Now, it's a very disturbing case, but I think it's somewhat atypical. That should be but atypical, but you don't see many judges behaving like this particular judge. Judges are generally very proper in the way they do things, very loath to imprison people, very patient, I think, with people who don't comply with orders. I think maybe too patient sometimes. So it's an atypical case. The judgment's a great read. It's very long, but it's really interesting. It goes through a lot of history, looks at all the various arguments, and goes back a long time because there's a lot of common law history there. So it's a good judgment. The conclusion was there was no immunity for inferior court judges, which obviously strikes at both the federal and the state and territory systems. So that's a concern. A lot of judges are making decisions at the inferior court level, and the question is, if they make an error bona fide in terms of jurisdiction, could they be liable? The suggestion is they probably could. Now, the question's been resolved at the federal level with the passage of the legislation. So clearly, federal circuit court judges and family court judges can relax. They can't be held liable for acting outside the jurisdiction and so on. But the question remains as to whether state and territory court judges might, in inferior courts, may be subject to personal liability. And it's going to be interesting to see what the High Court makes of this case. Obviously, I think it's going to have to rule generally about the distinction between inferior and superior courts. The case law seemed to be leaning towards this division between the two. Maybe the High Court will find there's no division and the immunity applies equally. But it'll be a really interesting judgment when it comes out. So hopefully you found that interesting. It's a very interesting case, very novel. Obviously, a judge getting sued personally for making some poor decisions in a case, and being found liable, and being found having to pay damages to the injured party, not just aggravated damages, but actually exemplary damages. So it'll be very interesting to see what the High Court decides ultimately and whether Wigney's judgment is upheld. If you have any questions about this particular presentation, feel free to give me a call or drop me an email. Bye-bye.